Do we have Mr. Harmon or Mr. Clark anywhere about?
Yes, we do. And they are prepared to come in and address the board. They just didn't know if you wanted to do it at this moment.
Yeah, I thought we'd try to resolve it as soon as possible this morning if we could.
Right away, Your Honor.
All right. Sergeant Rossi, why don't you have a seat? Nope, nope, not there. That's a juror seat. Are they on their way?
Yes.
All right. You read over Mr. Harmon's letter of today?
Today? No, I'm sorry.
May solve many of our problems. Ms. Clark, when did Mr. Harmon receive word to be here? I thought I told him to be here at 9.
No, I think there was a misunderstanding on it. We didn't know whether you wanted to communicate by letter or in person. And so we made a phone call and we wanted to be there.
He's from another county.
Gets us most of the way there. I mean, Ms. Clark, is he on his way? The ubiquitous Mr. Harmon. All right, back on the record in the Simpson matter. Mr. Simpson is again present with counsel. Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, Mr. Blazer, Mr. Scheck, people represented by Mr. Darden, Mr. Harmon, and Ms. Clark. Mr. Harmon, I have just received your letter dated today's date indicating that the Federal Bureau of Investigation will conduct the EDTA tests that they propose on Monday, February the 20th, and that you will be doing that on items 13, which are the socks, 59, and which I believe is a reference sample from Nicole Brown Simpson, 72, which is a Nicole Brown Simpson reference swatch, 86, which is a apparently a swatch cut from the black dress that Nicole Brown Simpson was wearing. Number 117, which is apparently a swatch from a, 117, which is a swatch taken from the rear gate, which apparently is at presently at the Department of Justice in Berkeley, undergoing RFLP testing, and number 17, which is the defendant's reference sample. Is that correct?
That's correct, Your Honor.
All right. The other biological items that you list in paragraph 2, my understanding is that you have no objection pursuant to Mr. Scheck's proposal yesterday to release those items for physical examination with their agreement that they will not test or consume any of the samples. Correct?
That's correct, Your Honor. And with the provisions that you made in your court order last week about us being able to be present and videotaped.
And or photographed, yes.
Or photographed.
As the case may be. Mr. Scheck, any comment?
Yes, I think this goes somewhat to alleviating our concerns, but a few questions. Number one, with respect to item 13, the sock, we have a strong desire to examine the sock itself. My understanding is that there is a cutting from the sock, and I presume that that is what the prosecution intends to perform this test on. And so we would like to have the sock available for immediate examination. That's really critical.
But it's really critical to their issue on EDTA.
Well,
It's indispensable to that, Your Honor.
well, I would indicate that in terms of timing, I really think that our needs in this regard take precedence, because any testimony that will or will not be offered about the presence of EDTA is certainly going to be subsequent to the appearance, for example, of Mr. Fung on the witness stand. And we need an opportunity to physically examine that sock, to have a trained criminalist examine that sock. At this point, all that has been permitted is Dr. Blake taking pictures of it, and that really isn't the same thing. And we're not going to perform any destructive testing. Now, they have a cutout of the area where blood was found. So it seems to me that, in fact, that's all they're going to be sampling anyhow when they do the EDTA tests. So it's not reasonable for us to be withheld the sock. That's just, and I'm just making that suggestion simply based on the assumption that EDTA testing ought to be performed at all, given the record before the court. But I'm just assuming that for the sake of argument before I address the issue. I'm just trying to be practical. I'm just making that assumption. So the first question that I raise is with respect to the sock. We want the actual sock. They can have the cutting that they've made if, in fact, that testing is to go forward. Secondly, I have a similar concern about item 117, which is the Bundy rear gate. Your Honor, the Bundy rear gate is an item that the prosecution obviously has had from the very beginning. They sent it out in September to the Department of Justice for testing. It was one of the matters that we had hearings and discussion about. I see no good cause why that testing didn't begin until essentially this trial began. It has nothing to do, the DNA testing has nothing to do with the issue of EDTA or opening statements. There's no good cause for the delay. And what's totally peculiar is that, this was something that even when we began this in the beginning of January, they did not indicate that they were going to be testing this. Now, as far as this sample 117 is concerned, we have some concerns about that being subject to EDTA testing, number one. But number two, I don't see any good cause why they should be have some priority around the testing of this when they waited so long, for no good reason that I can see, to begin testing on this in the first place. Finally, and this really gets to the crunch of the issue, there is no showing here by Mr. Harmon at all as to what is even necessary, how much sample is even necessary to do EDTA testing. Last night I looked at the submissions that Mr. Harmon made to the court about EDTA testing, which had to do with discovering EDTA in time-release cold capsules, in mousse, food substances where you already know it's there. That is an entirely different proposition than testing a sample of when you don't know whether or not it should be there. And this is really the most critical point, I think, is that Mr. Harmon was indicating yesterday that they have no idea how much sample is necessary to perform this test, even assuming that it could get past Kelly Fry and it's reliable on a forensic sample. I mean, I'm not even addressing that. I'm just saying in terms of what is reasonably necessary under Griffin, they don't even know how much sample they need. So let's take a look at 117, the sample from the back gate. Do they have to take...
How many swatches do we have from 117?
I have no idea.
I do.
Mr. Harmon?
I'll address that when Mr. Scheck's done. I don't want to cut him off. He's just getting started.
Well, there's no showing here. I was actually curious. The court had indicated that it had done some research of some kind. I don't know whether I misinterpreted that yesterday about EDTA testing.
No, if you'll notice the court order, I cite to a law review article that discusses EDTA. That's all.
That's all. Okay.
Something that's relatively available through Lexis. And
No, I just wanted to know what the knowledge base was.
virtually none, you can be assured of that.
Well, I don't want to profess that I have anything much greater, but I did discuss this matter with a defense expert who I think is considered one of the leading toxicologists in the country, Dr. Reeders, who informed me that before, I think, even the opening statement, although I'm not sure of the date, but I think it's at some time before, Mr. Matheson of the Los Angeles Police Department Laboratory had made inquiry of him about what literature existed or whether it was possible to do EDTA testing of this kind, and our experts sent him available literature here. But it's our position that the prosecution has to make a showing as to essentially what is the expected sensitivity of the test. That is to say, do they have any idea how much sample would be necessary to get a result one way or the other that they would claim to be reliable? And I'm not even addressing whether or not it could get past Kelly Fry or anybody's ever done it before. I'm just saying, because I don't think anyone has, I'm just saying that as a preliminary showing on the grounds of reasonable necessity to destroy samples, precious biological samples, they have to be able to tell us how much they need. If they need to consume nearly all of the swatches, or they don't know how much they need to consume one way or the other, it seems to me that they haven't even made a preliminary showing here. And they haven't done that, and I don't see, frankly, given the absence of that showing, what the great rush is in terms of EDTA testing prior to the defense having an opportunity just to examine all the samples so we can see what's there and we can figure out what regimen of testing, if any, we think would be necessary, and then the court can make a reasoned and informed decision based on scientific evidence as to what is reasonably necessary and what isn't. And it seems to me that in terms of the balance of equities here, in terms of who has the need to examine the material first, we merit priority here. On number 117, for example, which they didn't choose to test until very late in the game for no reason that is apparent to me. And certainly with respect to just looking at the rest of 13, the sock, I think we should have a right to look at the actual sock itself, and they can retain the cutting if they want for the time being.
Mr. Harmon?
Sounds like they really don't want us to find out what's in those two items, doesn't it, Your Honor? I guess we need to go back to last summer and last fall and remind counsel that while they may say we have to make certain showings in advance of testing, the law in this state has always been Griffin, and that's a retrospective concern. That's, if we want to introduce our evidence, we have to be able to demonstrate that whatever tests we done were reasonably necessary. And the court recognized this when you issued your order, that there was no proposition that the defense had litigated and caused undue consumption of time. The defense simply has no right at that point in time to insist that we make these showings. That's simply not the law in this state. We don't have to show why testing had not begun. You recognize that. And we sure don't have to show how much is necessary. On the other hand, if we can't justify, when they don't like the answers that will certainly come from these tests, if we can't justify why we've consumed what we have, then you have some rights and they have some rights to keep us from using the evidence, whatever results are produced from it. We understand that. We've always appreciated that. I can tell the court that the sensitivity level, and I'll describe why we need the sock in a moment, is approximately 50 parts per million. Now, I can't speak to what size stain that means has to be consumed. I can't address that. But we will address that when the defense certainly complains that we have proven conclusively that there's no EDTA on either of those two stains. So we're prepared to abide by the provisions of Griffin, but there's simply no reason for the defense to interrupt our testing at this point in time, especially after they have formally made serious accusations about the sock, and had they known that that is Mr. Simpson's blood on the rear gate in Bundy, Mr. Cochran would have alleged that perhaps Van Atta went over there and sprinkled it on the gate at some later date. He just didn't know that because those test results were just made available recently to Dr. Blake. So had they known that, they certainly would have made that accusation, And knowing that that's Mr. Simpson's blood on the rear gate, and we will definitively show that through the RFLP tests that are beginning today, that is why we have selected just those two items of evidence. But let me describe why we've selected the items that we have, because Mr. Scheck just doesn't seem to get the idea that we're trying to demonstrate that the failure to show EDTA is present means that it's not there, and this is why we need the SOC. We need the SOC because EDTA is present in many items, and if, for example, that SOC was improperly rinsed in the rinse cycle, there's EDTA in laundry detergent. So we need to do substrate controls. We need to sample extensively from that very SOC to prove that if there's EDTA on unstained areas in the SOC, that it's probably from one of these other sources in the environment, like laundry soap. If there's no EDTA present in unstained areas in the SOC, then that suggests that at least there's no background contribution from the SOCs that could have come from some other source. So having the SOCs as a control is indispensable to this as a scientific experiment to prove that this exquisitely sensitive test, when it says we haven't found EDTA anywhere in any of these items, that means it's not there. And that's why we need all the items that we've described. We need the reference samples, 59 and 72 from Nicole. We've had DOJ cut from a very large stained area on Nicole's black dress that certainly must be from her own blood. And that's another control, just to make sure that there's no EDTA present in her own blood, because many food substances have EDTA as a preservative in it. That's another vital control to the test. That's why we've also sent 117, the Bundy rear gate, which the defense knows is the tests are showing that that is Mr. Simpson's blood, and then Mr. Simpson's reference sample. So legally, we've tried to pare it down. They just don't want to wait till Monday. These tests should be done Monday, and the court realizes Monday's a holiday for everybody, but they're going to do it Monday. We're going to get it to the East Coast on Friday, and these tests, unless there's a power outage or a big blizzard, they'll be done Monday. And one of the things that they really haven't addressed is all of their experts, and this is something I touched on in my letter, we seem to have drifted from the court's order of requiring these things to be done locally, absent a showing of good cause. And we have no objection to whoever's doing it, but it just seems to me you've ordered them to do it locally, consistent with the case law that I cited, and they haven't made any kind of showing of good cause. I don't know if Henry Lee's the one who's going to look at all these other items, but he's not coming back from Seattle till Thursday night. I don't know about Doctors Baden and Wolf, but they're not losing any time. They can look at all the other items that we will make available to them and that we have made available to them. So we're just talking about a few critical items that if they want to try to look at them Monday night, if the tests are all done by mid-afternoon, we'll try to ship them up to them wherever they want them to be shipped or wherever you tell us to ship them the same day Monday. So to me, this is a big to-do about nothing, but it clearly reflects that they're concerned, they've made these allegations, and these test results will seriously undermine their credibility in the eyes of this jury based on Mr. Cochran's opening statement.
All right. Thank you, Mr. Harmon. Mr. Scheck, any brief response?
Yes. It sounds to me like, first of all, Mr. Harmon is explaining why there may be results finding EDTA in these materials ahead of time that he can then explain away if they find it. And he didn't tell us what 50 parts per million means in terms of the amount of blood that you have to have. Is that a half a milliliter of blood, which may be more than are on any of these swatches? But I think his argument really proves the wisdom of the suggestion that we're putting before the court. Before they cut up that sock anymore and perform a destructive test on it, even if they're using it for purposes of a substrate control, all we want to do is look at it. And our proposal would be is to have those materials sent to Albany, so our experts, all of them out there with their own instruments in a laboratory that's been dedicated for this purpose, can look at it over the weekend. That's what we really want. And the SOX, of course, is one of the most critical items because we want to just take a look at them. They can videotape that so that there's no allegation that anybody put anything on them. Our request is merely for a true physical inspection and examination, not a destructive test. They're asking to perform a destructive test, and the point here is simply which should take priority. And I don't see the great necessity to have them do that immediately, right now, before we even get a chance to look at them. That's all.
Right. Thank you, counsel. All right. As to items 1359, 7286, and 117, this all being prosecution evidence, they may maintain control of that item and have that tested by the Federal Bureau of Investigation Criminalistics Laboratory, that testing to commence on Monday, February the 20th. Immediately upon the conclusion of those tests, the prosecution is to make those samples available immediately to the defense for their inspection and testing pursuant to the court order. Court notes that as to the critical item number 13, the SOX, that the defense has had the opportunity to view these items at the Department of Justice, although not examine them in a private setting. The prosecution is ordered to turn over the items listed in paragraph 2 of Mr. Harmon's letter of February the 15th forthwith to the defense for their testing pursuant to the court's previous order, and the non-biological evidence is likewise ordered turned over to the defense for their testing. I do make a finding that given the location of the defense experts, all of them apparently on the East Coast, and the laboratory facility being available in Albany, New York, that they have shown sufficient cause to test those matters out of state. However, the court warns that there will be unbelievably negative sanctions should these items become lost or destroyed.
Your Honor, can I just interject one thing? I'm not sure if you noted in my letter, Mr. Hodgman on the non-biological evidence has asked just to have a couple of hours to review that, and I don't expect anything will be accepted, but I just wanted to advise the court.
He can come and ask me for a good cause exception to the court's order.
Okay, thank you.
All right. Thank you very much, counsel. All right. Is there anything else before we resume with Sergeant Rossi? All right, Deputy Higgins, let's have the jury, please. All right, good morning, ladies and gentlemen. My apologies to you for the delay in getting started. However, you should know that we have been in session on other matters since 8:30 this morning. Sometimes these things take longer than I anticipate that they'll take. All right, Sergeant Rossi, would you come forward, please? Resume the witness stand. All right, good morning, Sergeant Rossi. You're reminded that you were still under oath. Mr. Bailey, you may continue with your
I
cross-examination.
approach the witness, Your Honor.
You may.
Sergeant Rossi, I hand you what has been marked Defense 1013 for identification, and ask you to look at it to see whether or not you can tell me that that represents a map of the area showing both the police department and 875 South Bundy at the intersection of Dorothy.
Yes, it does.
And do you see a scale on that map?
Yes.
What is your present estimate of the distance between, by road, the distance between the police station at 1663 Butler Avenue and 875 South Bundy?
3 to 5 miles?
3 to 5 miles?
Yes, sir.
How about 1 mile, 2,842 feet?
Objection. Is counsel testifying?
It's a leading question.
Doesn't it look more like a mile and a half?
It looks a little more than that to me, sir.
Okay. When we adjourned yesterday, Sergeant, we were talking about the possibility that the coroner had not been notified as of 5 a.m. My understanding is that you personally didn't know of anyone having notified the coroner of these homicides by 5 a.m. Is that correct?
This is the same objection as yesterday.
Overruled.
Yes, sir, that's correct.
Okay. Now, is there any requirement that you, as a police officer, have some familiarity with the laws regulating the conduct of homicide investigations?
No, sir.
There is none.
As if I understand the question, laws regulating the conduct of the investigators that are handling the case?
No. Is there any requirement that you have familiarity with the laws that regulate homicide investigations?
Yes, laws of the state, yes.
All right. Are you familiar with any law that dictates when the coroner should be notified when a death has occurred?
No, I'm not, sir.
You never heard of such a law?
No, I didn't.
Did you ever hear of Section 10250 of the California Penal Code?
Objection. You hear your question.
No? Yes or no? Are you aware of the code section?
No, sir.
Do you know that it is... I'm sorry. I'm told I misspoke. Not the California Penal Code, the Health and Safety Code. Do you know there is a Health and Safety Code?
Yes, I do.
All right. Have you ever reviewed that code?
The entire code? No, sir. I
Any
know.
sections of the code that might pertain to your work?
Yes, some.
Are you familiar with a section that deals with the notification of the coroner in certain circumstances after death?
No, I'm not.
Objection. That's not his witness' job.
Is that illegal? Counsel, let me see over at side. All right, thank you, counsel. Mr. Bailey.
Sergeant Rossi, you said that you were familiar with certain parts of the Health and Safety Code.
Your Honor, may I please see what counsel's reading from?
You already have at the bench.
No, he smashed it out of my hands, Your Honor. May I
Ms.
please-
Clark, have a seat, please.
Do you remember the question, Sergeant?
Yes, sir, I do. And yes, I am familiar with some sections.
Are you familiar with any portion of the Health and Safety Code that mandate the calling of the coroner in a homicide case?
No, I'm not.
All right. Do you from time to time review the LAPD manual?
Yes, sir.
Do you ever look at Volume 4?
Occasionally, yes.
Okay. And what about Section 238.46 entitled Notification of the Coroner? Do you ever look at that?
I don't believe I've ever looked at that, no.
Okay. Would you like to look at these two provisions to refresh your recollection, perhaps?
If you would like me to.
I would like you to.
Objection, have me refresh your recollection.
Sustained.
I thought you said that you did, at one time or another, acquaint yourself with the provisions of the Health and Safety Code.
Some sections,
All
yes.
right. Do you ever recall reading anything about the mandate to notify the coroner?
No.
You don't. Were you, in fact, in charge of this crime scene from your arrival at 1:25 a.m. until 2:10 when Detective Phillips showed up?
Yes, I was.
All right. As one in charge of the crime scene, were you not obligated to carry out any legal duty imposed on the boss?
Repeat the question, sir. I don't understand it.
Were you obligated to carry out any legal duty imposed on the person in charge?
Repeat it again. I just don't understand the question. I was in
I'll
charge
repeat
until
it again.
I was in charge until the detective showed up.
No. We're talking about a bracket from 1:25 to 2:10. Do you understand that?
Time bracket.
Yes.
Yes.
That's 45 minutes. Is it not?
Yes.
You had the means of communication at hand, did you not?
Yes.
Now, did you, during that 45-minute period, have a legal duty to call the coroner?
Not as far as I know. No.
Did you know it was a misdemeanor to fail to call the coroner, Sergeant?
I don't believe it is, sir.
May I now approach the witness and show him the section?
I don't know what he's showing. Can I please see it, Your Honor?
Is that an objection for relevance?
Relevance?
Sustained. Thank you.
So that if there was such a law on June 13th, 1994, you were not familiar with it. Is that correct?
Yes, correct.
Okay. And if you violated that law, it was unknowing on your part. Is that correct?
Calls for a legal conclusion. Sustain. I'll sustain
Very
the
well.
court's own objection. Now, Mr. Bailey, this is a rather limited area of inquiry with this witness.
I understand that.
Thank you.
Is there any regulation, quite apart from the Health and Safety Code, in the manual of the LAPD that requires you, when you're in charge of a homicide scene, to notify the coroner promptly?
Not unless I'm instructed by the investigating detective.
What regulation are you referring to that says you're exempted from that obligation unless the investigating detective orders you to?
That's our department's policy, sir.
Where is the policy printed? Can you
Have-
tell us?
No, I can't.
Is it any part of Section 238.46 of Volume 4?
I don't know.
Have you ever read that section?
Probably, but I don't remember how long it's been. But yes, I probably have. I read the entire manual when I was studying for sergeant, so. That was
But you
long.
don't now recall what's in it.
Not that section, no.
Would it refresh your recollection if I showed you that section?
Possibly.
May I do so?
You may.
Can I please see it?
Yes.
Would you examine that?
Which section is it? This one here? 238.46?
Yes.
Okay.
Do you find anything in that section that exempts you from needing to notify the coroner until the detectives arrive?
Yes.
Would you read the section, or that part of it, which you believe exempts you from that obligation?
It shall be the responsibility of the investigating officer to notify the coroner of deaths occurring. And I was a preliminary investigating sergeant, and I take this as investigating officer, meaning the responding detectives.
Okay. Now, when you personally observe another policeman violating the law, what is your obligation?
Objection, relevance?
Overruled. I think we've already asked this question, though.
May I ask you?
Sustained. Yesterday.
Sorry. Are you familiar with Section 210.46 of Volume 1, dealing with misconduct of officers and the duty to report?
Yes, sir.
All right. Did you ever hear any detective call the coroner that morning?
No, I did not.
Did you ever report the fact that the detectives had violated the rules of the manual?
Objection, that assumes facts not necessary.
Sustain.
Very well. What obligations do you have to make reports of homicide investigations of this sort when you are at least temporarily in charge of the matter?
The only obligation that I have is to ensure that a crime scene log is being completed.
And how did you carry out that obligation that morning?
When I arrived at the scene, I asked Sergeant Marty Kuhn, who was handling the crime scene log, and he indicated that it was a police officer by the name of Chris Cummings, and he was standing very close to my proximity, and I saw that he was in fact engaged in that duty.
And did you take any further steps to assure that the crime scene log was being accurately carried out?
No, sir.
Have you ever examined it to see that it reflects what you remember?
Have I ever examined the crime scene log? Yes, I've looked at it.
Okay. Did you find inaccuracies there that you were able to report or log?
No.
According to the crime scene log, are various people on the scene at given times, and the departure reported is unknown, if you know?
I'm sorry, sir, what was the question?
If you know.
If I know what?
Whether or not, as to certain people, including the lieutenant and your superior, Captain Dial, the departure time was logged as unknown. Did you ever inquire into that?
No, I did not.
Did you notice, for instance, that Detective Phillips arrived at 2:10 and didn't leave till 10 a.m. from Bundy?
I believe I saw what time he logged in. I don't know what time he left.
My question is, when you reviewed the crime scene log, did you notice that according to it, Detective Phillips arrived at Bundy at 2:10 and didn't depart till 10 a.m.?
No, I didn't note that.
You know that's false, don't you?
No, sir, I don't know that's false.
Didn't he call you from Rockingham?
Yes, sir, he did.
You now know it's false, don't you?
Yes.
Okay. But this is the first time that's been brought to your attention.
Yes.
I take it that your review was somewhat cursory.
Yes, probably so.
Okay. And of course, that same entry as to Detective Furman would be wrong, wouldn't it?
Possibly. It's not my job to review the crime scene log, sir. That goes to the detectives.
I thought you did review it,
I looked at it.
but because it was not your job, you didn't look at it carefully. Is that what you're telling me?
I didn't scrutinize it, no.
Okay. Now, when Officer Risky called you first, I take it you did not note the time on any piece of paper or log.
No, I didn't.
Did you satisfy yourself from your conversation with him that the victims were both deceased?
Yes.
Did he tell you that he touched the eye of one of the victims to ascertain that?
Not at that time, no.
Okay. Did you later learn that?
Yes, sir.
Did you later learn how he accomplished that?
Yes.
What did he tell you?
He told me he went around to the north side of the male victim, and I believe he said he reached through the fence.
So that he wasn't trampling on the crime scene?
Yes, sir.
Okay. When he said the crime scene is secure, as I understand it, you accepted that?
Yes, sir.
Did you know at the time you accepted it that his training in crime scene protection was entirely superficial?
It was Sergeant Kuhn who told me the crime scene was secure.
I thought you told us yesterday that Officer Risky told you that before Sergeant Kuhn's arrived. Did you not?
No, I didn't.
You didn't say that.
Well, he did call me, and he told
Did
me
you
what
say
they
it?
had, but I don't remember saying that.
Did you say that? Yes.
I don't remember.
All right. Now, how would you like to leave it? Did you or did you not at any time rely on the testimony or the statement of Officer Risky that the crime scene was secure?
I may have. I don't remember if
All
he told
right.
me that or not.
And if you did rely on that, did you know at the time that his training was by his own account superficial?
Objection, that misstates the testimony.
I'm sorry, glossed
Sustained.
over.
Objection, still misstates the testimony, that's not the only training we could do.
Sustain.
Did Officer Risky ever tell you, when you were discussing the security of the crime scene, that his training in crime scene protection had been glossed over?
No, sir.
Objection, that misstates the testimony.
Overruled.
Okay. I think you mentioned yesterday that Detective Phillips was making notes at the crime scene?
He had a notepad with him.
No. Did you see him writing notes?
I don't believe I saw him writing notes. I assumed he had been.
Okay. Now, was there some interest in learning the identity of the male victim at the crime scene?
Not by me, but I'm assuming there was by the detectives.
You mean during the 45 minutes that you were in charge, you didn't care who he was?
It wasn't that I didn't care, sir. It wasn't part of my job. I was more interested in securing the evidence there.
Was it important to notify his next of kin who might be threatened, as you agreed Mr. Simpson might be?
It was important, I think, if I was instructed to do so by the detectives, but at that point, that wasn't what I was going to do.
Is the police department frozen tight until the detectives arrive?
In some cases, yes.
On this occasion, apparently. Is that so?
To a certain extent, I was waiting for instructions from the detectives, yes, sir.
After 300 homicides, you didn't incline yourself to try and find out who had been killed. Is that right?
No, I did not.
Okay. What was the purpose in taking and running through the computer the tag numbers on the vehicles in the area?
Possible witnesses?
Was it of interest to you to know which of the two victims might have been the primary target of the assassin or assassins?
Objection, it's beyond the scope of our evidence.
Overruled.
I think that would be interesting to know from a detective standpoint, yes, sir.
Not something in which you had an interest?
No.
Okay. Is it true that until 5 o'clock on June 13th, nobody knew that the male victim was Ronald Goldman? If you know.
I don't know.
Is it true that as of 5 o'clock a.m., when you were on the phone with West Tech, trying to help the officers get into Mr. Simpson's home, that you had no idea who the victim was?
That's true.
And when is the first time you ever heard the name Ronald Goldman?
I don't remember. I don't remember even it was that day.
Did you read it in the papers?
Oh, I may have. I don't recall.
Thank you.
Ms. Clark?
Sergeant Rossi, is it your job to take notes at a crime scene?
No, it's not.
Is it your job to notify the coroner?
No, it's not.
Is it your job to direct the investigation?
No, it is not.
Is it your job to call for a criminalist to appear?
No.
Is it your job to ask for a photographer to come?
No.
Is it your job to ask for a print expert to get there?
No.
Is it your job to direct the search at a crime scene
No.
or the collection of evidence?
No.
What is your job when you go to a crime scene?
As a watch commander, my job is to ensure that the crime scene is secure and that any evidence is protected, and to make the necessary notifications to the detectives and to my command staff.
So you are not trained per se in homicide investigation, is that right?
Sustained.
Are you trained in homicide investigation, sir?
No.
And so are you there to maintain the scene for the detective who is trained in homicide investigation?
That is correct.
And so when you say it's your job to secure the crime scene, as you referred to checking the perimeter in your testimony yesterday, do you remember that?
Yes, I do.
Is that what you were talking about in terms of securing the crime scene?
That's correct.
So you make sure the crime scene tape is where it's supposed to be,
That's part of it, yes.
and that nobody goes in through the tape who isn't supposed to.
That's correct.
And you do that until the detective who's handling the case gets there?
Yes, I do.
Now, you indicated that you've been to, what, 300 homicide?
In the neighborhood of 250 to 300 in my career, yes.
And have you been to other homicide scenes in your capacity as Sergeant Watch Commander on previous homicide cases?
Yes, I have.
And in those other homicide cases where you appeared as in your capacity as Watch Commander, what function did you perform?
The exact same function that I performed at this homicide.
You mean in those other cases you did not notify the coroner?
No, ma'am.
You did not attempt to ascertain the identity of the victims?
No, I did not.
You did not attempt to call for criminalists
No.
or photographers
No.
or notify coroners?
No. I have done that, but only under the direction of the detective.
when the detective handling the case asked you to do him a favor and help him out.
That's exactly right.
So this case was no different than the others.
No, it's not.
Your Honor, been patient. Every question is leading.
Sustained.
Now, you indicated that you needed to observe the scene before before you saw the detectives who were going to handle the case.
Yes,
Why is that?
because the detectives will come to me before anybody else and ask me what we had here, and I need to give them a brief overview of the scene, so when they start walking through it and taking a look at it, they know where to step and where not to step and what to be looking out for.
Okay, I think you indicated yesterday that Officer Risky told you he thought one of the victims might be related to Mr. Simpson. Is that correct?
Yes, he did.
But at the point that you got there, was there a confirmation of that information?
No, there was no confirmation.
Have you ever made notification to the next of kin in a homicide case?
No, I have not.
Are you aware of any policy with respect to how it's supposed to be done, by telephone or in person?
That's done in person if at all possible.
And is it also a requirement that you confirm the identity of the victim before you go making notifications?
By all means.
So until it's confirmed that the what the victim's identity is,
Objection, Mr. Hart. That's
Sustained. It's leading.
which question was leading? Sorry.
all.
Come on over here to the side without